C'est sur mute, on attend.
On attend.
Ouais.
Ok.
Hello everyone, good afternoon. My name is Ali Boudrin. I'm a partner of UGGC law firm in Paris and in Morocco. We will start in a few minutes, waiting that the attendant will connect. Meanwhile, I will ask you please to put your microphone on mute during the webinar to avoid any disturbances during the webinar. Thank you for that. Hello everyone, my name is Ali Bougrin. I'm a UGC partner in France and in Morocco. I will have the pleasure today to be the moderator of our webinar. First of all, I will ask every attendant to put their microphone on mute with the webinar in order to have no noises during our participations. I would like, first of all, to thank you for joining this webinar, which is a result of a joint initiative between the UGGC network and the French Chamber of Commerce in Brazil and the Brazilian Chamber of Commerce in Paris. We will consequently and therefore have a return of expertise and experience from the partners of the UGGC network located in Europe, Asia, Africa, and South America. They will have the opportunity to speak about the advantage and also inconvenience of using alternative dispute resolution method, such as arbitrations, mediation, and conciliations in a COVID and post-COVID scenario. All the attendants will have the opportunity during the webinar to formulate questions using the chat applications. And we will have at the end of this webinar a Q&A session of 10 to 20 minutes in order to address all your questions. We have chosen this topic because we are rethinking that, especially during these special times, that arbitrations and mediations were an important and crucial topic. Indeed, we can see that all judicial institutions all around the world have often been paralyzed during the health crisis that we faced and accumulating substantial caseloads, and in a context where delays were in processing such cases were very problematic. Because of the time needed to catch up these delays, and considering the new health regulations, the rule of dispensations, we think here as a professional that these rules will necessarily have an impact regarding the new way to hold hearings. And we anticipate, as most practitioners as well, in a post-COVID scenario, a higher recourse of arbitrations. So, without further ado, I will give the floor to Delbert Lage, our partner in Brazil and London, who will speak to us about the advantages of using institutional arbitration in the period of health crisis that we are experiencing. I think, Delbert, your microphone is on mute.
Sorry, always happens, sorry. So thanks, Ali, a lot for this. Such a pleasure to have the opportunity to exchange ideas with you guys and with the others that are watching us and might eventually send some questions. I believe that as a response or as a result of the whole COVID crisis, of course, there are lots of cost efficiency questions being raised within businesses in terms of the best course of actions of those businesses. And of course, lots of litigation issues arising as a result of the COVID. So of course, that the main purpose of this webinar is to understand the role that arbitration, institutional arbitration can play in solving those issues. And of course, answering some questions or shedding some light in issues that companies, the corporates, the entrepreneurs might face in their own businesses, and the implications that different levels of engagement with arbitration and different forms of arbitration could play in particularly in the business. So the main goal here, of course, is to put some ideas for you to think about it, to consider some relevant elements and changes that we are seeing in the arbitration landscape as a result of the COVID, and then, of course, take it from there to further discussions. In this initial part of my exhibition, I will say a few things about this cost efficiency concern, how that might impact approaches to litigation and particularly to arbitration, and then how changes in the existing procedures of different chambers of arbitration and actually visual or digital procedure might play a relevant role in this whole scenario. So that being said, it's very relevant that people or companies, corporates who are involved in issues with other parties take a deep assessment about what could be their litigation, the future of their litigation procedures, and also to consider how the arbitration choice could impact those. And by that, I mean both in terms of existing arbitration procedures or those that might arise in the near future. Either if you have an initial issue with the other party, or if you have good commercial terms with them, you should consider what would have happened in a case of a future litigation. And of course, as we all know, context of crisis such as this one, lots of claims tend to arise as a result of businesses going bankrupt, business needing to review their priorities, so on and so forth. So this is a very, very relevant moment for legal counsels and people related to those issues to sit down and actually understand what is at stake and how should they react to those challenges, and one might say also to opportunities in this sense. So of course that every time that a corporate faces a claim, one of the key elements for them to assess is the cost correlated to that or to pursuing that claim. So what's the likelihood of them winning that claim? What's the nature of the claim? Will they have to spend lots of time and effort to put together all the elements, documents, information needed to pursue that claim? What are the transaction costs involved? And most importantly, what's going to be the jurisdiction venue that is going to be chosen? It is going to be a regular court. It is going to be an arbitration court. But in addition to that, in addition to cost considerations, they should also consider efficiency elements. How long is it going to take for this to get decided? What resources should I allocate in terms of get the best efficient outcome? And more than that, what are going to be the impacts that the coronavirus or corona crisis is going to have into that? And in terms of those impacts, and that's a relevant element, those could have an impact in the proceedings per se, because if most of the proceedings are being carried in person, they should be put on hold or they should be delayed as a result of all of the measures that we are having to put in place to avoid the spread of the virus. On the other hand, if there is a chance for these measures or for these procedures to be carried virtually, of course, that this can speed things up and we can come to a decision quicker in this whole scenario. So parties should be really aware of it, should be really aware of the choice of the jurisdiction chamber of arbitration and the impacts over their claims. But most importantly, in a scenario of crisis, they should also consider the impact of the cash needs that claim is going to make on their businesses and also on the other party businesses. It's not only about winning the case, it's about being able to recover the payments that might be allocated to one party in the decision of the arbitration case. So lots of considerations should be made in terms of the cost and efficiency. And of course, those considerations might be different depending on the approach and the stage that you are upon. Are you choosing the arbitration court on a contract that you are negotiating right now? Then we have one set of considerations. Are you looking at raising a claim for an existing contract with no litigation yet? Then you have to consider another set of variables. And most importantly, are you in the middle of a litigation process at the moment? And how this litigation process within arbitration court might be impacted as a result of the crisis. We are seeing many arbitration courts or chambers adapting their processes and trying to expedite things. I can give an example of the London International Court of Arbitration. They were about to publish new procedures, new rules, and they have suspended it as a result of the corona, but they have relied on the regulations of 2014 and implemented many measures to expedite things and to make hearings and other part of the procedures virtually. So again, parties should be really aware and should try to play within these rules and these changes in order for them to have an advantage over the others. But in that sense, and considering that part of the element, I will defer the floor now to Zen, our partner, who is going to be talking a little bit more about that and about its implications in China as well. Thank you, and of course we will come back to other subjects and all the discussions soon.
Thank you, Delbert, for your interesting shed light on how institutional arbitration could be a really good alternative to have efficiency in litigation during the coronavirus crisis. As you said, we will give the floor now to Chen Wang, UGG's partner in China, who will speak about this situation in particular in China. Thank you, Jen.
Thank you, everyone. My name is Huang Zhen. I'm in charge of the UGGC Shanghai office in China. So I'm very happy to give some presentation of arbitration system in China. First of all, arbitration system is very in use and very preferred method for resolving disputes, especially by foreign enterprises and foreign-owned companies. The reason for which is the arbitration court is more specialized in the business than the state court. The second one is China is a member of New York Convention. That means that foreign arbitration award may be enforced in China. Even you have to apply for recognition and enforcement to Chinese court, but the principle is to have enforced foreign award is possible. Arbitration system is easier and is faster than the court decision because there's no appeal possible. Arbitration as well as more confidential, that the information according to the public proceeding, you can keep the all information confidential within the arbitration court. And finally, arbitration system is more flexible for choosing the language, choosing the place, choosing the arbitrator, choosing the arbitration rules, etc. Especially in China, for example, for the court, if you have to provide the evidences, there's some rules very strict. For example, some documents from foreign countries have to be legalized by the Chinese consulate in the country, and it's may be very expensive and take very a lot of time. But for arbitration procedures, such how to say requires is more flexible. The specification of the Chinese arbitration, the first thing to say is that in China, only institute arbitration is recognized. That means no any adult arbitration may be recognized and enforced in China. So this lead to well draft the arbitration clause in a contract, if you must absolutely very clearly indicate the name of arbitration institution and the rules to be applied for the arbitration procedures. If not, Chinese court will not recognize the arbitration award, and which has no possibility to be enforced in China. In China, another specification is there is domestic and international arbitration. When you see international arbitration, it's not only the arbitration made abroad. It's maybe arbitration in China, but involving a foreign element. That means foreign element may be, for example, arbitration in China by both two companies, foreign companies not established in China, or only one party to the arbitration is a foreign company, or the contract is signed, is executed in foreign countries, or a party is a company, foreign invested company, that is joint venture, or some company invested by a foreign investor in China. This is international arbitration. Means international arbitration. You can use the foreign languages. You can use how to say application law is foreign law, and you can choose the foreign arbitrator for the procedures. The arbitration clause is like everywhere, but you have to, as I said before, you have to very careful for indicate the arbitration institution, especially for the arbitration abroad. In China, you have the CETAC, the biggest arbitration institution in the world for the number of the cases traded every day by this commission. But in foreign, if the arbitration organization is not well drafted, it's maybe a reason to refuse the enforcement of the arbitration award. Some choose the arbitration institution in China up to end of the 2018. There's more than 250 arbitration institution in China. The biggest one is the CETAC. Is even I think it's more. They have more decision per year, even compared to the ICC. Just a figure, in 2019, they have made more than 3,000 decisions in the year just for this one organization, and that means almost 10 decisions per day. Is very huge figure. So the choice is to do between Chinese institution or Chinese arbitration organization or foreigners. The difference is if you choose a Chinese arbitration institution, for enforcement is easier because the Chinese court can recognize more easier a decision made by a Chinese arbitration institution. But if it's a foreigner, including Hong Kong, International Arbitration Center is considered as a foreign arbitration institution. So you have to apply the recognition under the enforcement of the foreign award is take more time, and there has the possibility to be refused, even if, according to some figure, the refusal of arbitration for the arbitration award is less than 1% in China in last years. So this is the main topic of Chinese arbitration system. Just one last word. For the enforcement, you have to apply to the court. The foreign arbitration award cannot be enforced automatically. It's absolutely to apply to Chinese court for utilization and for the enforcement. And this could be a procedures very, very complicated and sometimes take a lot of time. Okay.
Thank you, Jen. It's really interesting to know that in China and in other parts of the world, recourse to institutional arbitration is really efficient. We can note that, as Delbert has highlighted, that his arbitration institutions have adapted their process to the coronavirus crisis. As Delbert said, they have provide some guidelines in order to adapt the process to the current context, favoring electronic filings, virtual hearings, and in order to promote this and continue to deal with current and pending arbitrations and to deal with the coming ones. But nevertheless, as a professional, we always face to one question, big questions of our clients, which is, yes, we recognize the efficiency of arbitration institutions, but the cost, notably, could be significantly a huge inconvenience from clients to have some recourse to arbitration, and these considerations lead them to go to judiciary institutions, courts. But between these two solutions, they forgot always their go-between between institutional arbitration and judicial institutions, which is ad hoc arbitrations. We have seen from what Jen told us about that ad hoc arbitration is not possible in some countries, such as China. But in, I would say, the large part of the world, the judicial system recognize ad hoc arbitration and provide equal, I would say, force and enforcement to awards issued by ad hoc arbitration courts. But since first, what is an ad hoc arbitration? Basically, ad hoc arbitration is where party agree to arbitrate a particular contract or dispute without referring to any arbitral institution. It differs from institutional arbitration by the absence of recourse to an arbitration chambers to supervise and to regulate the arbitration process. What we could say about the major advantages to recourse to the ad hoc arbitrations comparing to the institutional arbitrations? First of all, the greater flexibility. Indeed, there is a total freedom left to the party in the organization of the arbitration procedure, which is a significant advantage in the current context with the coronavirus, meaning that the time schedule, the hearings, the calendar, the way to hold the hearings, the actually filing could be freely decided by the party, either in the clause, but more often in the ad hoc arbitration agreements. One other advantage, ad hoc arbitration is faster comparing to arbitration institutional. Yes, there is a greater speed due to the simple fact that the parties are distanced with mandatory steps and delay and controlled by institutional arbitrations. But we will see that it's not always, unfortunately, the case. We can also highlight that there is an increase of the level of confidentiality. It's basic. There is, since less people are involved in the process, and specifically no administrative support employee of arbitral institution involved in the process, just the party and their advisor directly, and the arbitrator, of course. The risk of breach of confidentiality should be reduced. But the main, I will say, decisive comparison between these two ways of arbitration is the cost. What is the basic difference? First of all, there is no administrative fees in arbitral chamber that apply to parties, which is a significant advantage. And secondly, the arbitrator fees are not governed by any scales, as is the case in arbitral institutional arbitration. Therefore, an arbitrator to decide the fee, the level of fee, will take in practice, they will have the ability to adapt the level of fees considering the importance of the dispute and financial capacity of the party. Especially, this is crucial, especially in this currently context of coronavirus with the negative consequence on the financial capacity of the party sometimes. And we will see that the cost issue is sometimes preventing some people to go to arbitration because of the cost. And we will see in a few minutes we prepare the alternative to solve this issue of financing arbitration. But okay, yes, ad hoc arbitration is less expensive. But we have to talk about the efficiency of this type of solution, because it's not a perfect solution. I think ad hoc arbitration for my practice is more adapted to, I would say, middle level of importance disputes and domestic arbitration. It could be very complicated to use ad hoc arbitration in a context of international arbitration. For instance, when you have to serve notice to the international party, you have to rely on domestic rules who can have a significant impact on the delay, which is not applicable to international arbitrations. We can note as well that sometimes the advantage of ad hoc arbitrations is reduced by the fact that the party need to have the support. When you have an ad hoc arbitration clause, you cannot, of course, provide any details in your clause. You will have the main elements of the principle who will govern the ad hoc arbitration. And sometimes party recurs as a supporting regulation to their ad hoc provision to arbitration institutional rules. So you have municipal rules that are commonly applying to ad hoc arbitration to support arbitration, but it means that if you have litigations and a dispute between the parties regarding the enforcement of the clause, you have to go to the institutional chambers as a supporting, I would say, arbitrator of litigation between the parties, and you fall back in the way and the process of institutional arbitration. And the whole point of ad hoc arbitration is to avoid these additional fees, costs, delay. So this is not a perfect solution. I think it's simply fit to the current situation with the coronavirus, but it means that the party should carefully, one, draft very carefully their arbitration clause, to decide and negotiate the arbitration ad hoc agreement with a careful intention, and insist on the fact that virtual hearing will be possible, electronic filing will be possible, and to provide all the things relating the process, and in order to avoid in life. Because sometimes what we have seen in the arbitrations, when the party have not choose sometimes rules of institutional arbitration as supporting regulation, we have a lack of provision who could lead to difficulties. You have to go back to the institutional judiciary institution. You have to go to the common court sometimes as a supporting judge to sometimes decide regarding the appointment of the arbitrator, to judge on the impossibility or a different interpretation between the party of the clause. And in the context of the coronavirus, because we have faced in the past some blockers in the course, this will lead automatically to block the enforceability of the clause arbitration. So ad hoc arbitration is not perfect, but for our clients, it's a way to mitigate the huge difficulties that sometimes they will face, and especially regarding financing the arbitration. So my advice will be, yes, the arbitrations could be a very interesting alternative, a subject that is legally permitted in your country, first of all, and secondly, that your provision clause and ad hoc arbitration agreement should be very carefully drafted. To come back to the cost, there is another way to, I would say, avoid the most inconvenient disadvantage faced by the institutional arbitration, which is the financing. Albert will speak about an alternative to finance arbitration, which is the third-party funding. So I'll give the floor right now to Albert.
Thanks, Ali. And thanks a lot as well for the quite interesting angles in terms of how and when parties should make recourse to the ad hoc arbitration. As you have highlighted, as opposed to the institutional arbitration, this can be, let's say, assessed on the go as the claims arises, but of course has its own or challenges and particular perspectives and assessments to be made in regards to the cost of the arbitration procedure. And that's a very relevant element. When I highlighted in the beginning of this webinar about the considerations that must be made by the corporates and parties in terms of initiating or not a litigation procedure, and particularly an arbitration procedure, the cost element is very relevant. It's always a thin balance between how much you should be spending to put together the claim, to initiate the procedures and to maintain the procedures and to manage the case. And on the other hand, the likelihood of you getting a positive award and then being able to enforce that award at the end of the day. So a couple of different variables should be considered. How much will that impact my cash flow? Is the claim big enough that would justify my investment or allocation of resources to make this into a successful case? And how much I will be investing now or allocating now versus what I could be receiving in the future. So that's the first element. What is the feasibility, I would say, and we can think on those terms, what would be the feasibility of me allocating resources at the moment, considering my company or my own personal status, versus the ability that I would have to recover the proceeds of this positive award in the future. So that being said, that is one of the key elements that we need to consider during the coronavirus crisis. As I said, there are immediate implications in terms of the costs of the procedure itself. Either the chamber or the court having adapted themselves to virtual and electronic proceedings, but also from the pure digital nature of some of the chambers. But in addition to that, we should also look at the other party's ability to repay any of the awards that might be granted on one of the parties' behalf. And that's where the institute of third-party funding starts to be somehow interesting. It is not a new practice. I mean, funding third parties for them to pursue claims, it's something that we can go back in time and find examples in decades and centuries ago. But of course, that within the arbitration framework and institutional and even ad hoc arbitration framework, we are seeing more and more of that. We should highlight the massive use that this sort of institute has seen in countries such as the United Kingdom and the United States of America. But this is becoming more and more a practice in other regions, in Latin America as well. I will speak a little bit about Brazil and give some rough understanding of how this is being performed or carried in Latin America. But for those who are not familiar with the Institute of Third-Party Funding, the underlying idea here is and I'm putting myself in the shoes of a company that has a claim to pursue. And I could see an eventual significant likelihood of my claim getting succeeded. I can see some degree of likelihood of the other party having resources to repay for that, but the initial cost of the setup of the arbitration and the maintenance of the arbitration procedure might be too expensive for my cash flow at the moment. I might be suffering from the corona crisis, not receiving what I should be receiving from some of my customers, and therefore, although I could have a good chance of success as a claimant, I might be in a situation where I could not pursue this due to the lack of my own resources to go after and to pay for the expenses of this arbitration, for example. In such cases, it's not unusual for some parties to seek what we call third-party funding. They would reach out to a party that has no interest and nothing to do with that particular claim or litigation, and they would ask for that third party to fund the proceedings that could eventually include out-of-pocket expenses and other expenses correlated to the arbitration procedure, in order for this third party to have an upside by the end of the litigation or the arbitration, should the award be positive for the party that this third party is funding. So in this case, I would say to the third party, look, I have this claim, these are the elements of the claim, this is the other party, this is the likelihood of me getting a successful decision and enforcing the award. Would you like to finance this claim? Would you like to finance my expenses during this litigation in order for me to share with you some of upsides of the claim at the end of the litigation? So that's the underlying idea, is for one to invite someone else to support them financially while this interest party, the claimant usually, but it can also be for the defendant, to carry on the proceedings during negotiation. Of course, that this must be disclosed during most of the proceedings, and there are going to be lots of concerns being raised about conflict of interest and other correlated elements. But matter of fact, in most of the geographies, this is a practice that is acceptable, and that could, of course, be one of the resources that claimants or that corporates might recur to in order to make feasible their application to certain arbitration procedures or their initiation of certain litigation matters. So lots of relevant concerns here in terms of how this could impact positively or negatively the understanding of the court and of the other party. So we can come back to specifics in another element, but be mindful that this can be a very, very interesting way for you to have access to resources that would allow you to carry on in a procedure that otherwise you wouldn't have enough funds to pursue. In terms of the application of this sort of institute in Brazil, as I have said to you, it was not very usual in the past. Arbitration per se is something that is getting more and more applicable in Brazil in the last couple of decades, but the third-party funding is a subject that is seen some increase in the last 2 years, I would say. Although this is relatively new in Brazil, there are lots of potentials over there. I mean, the number of arbitration procedures being initiated is quite significant. It is increasing rapidly, lots of new chambers as well, and more people, corporates and legal counsels being aware of the benefits, advantages of certain use of arbitration. And of course, as a whole, Brazil is a country in which we have, for you to have an idea, on the regular courts and tribunals, more than 78.7 million lawsuits at the moment. So there is a huge potential for this institute to be applied. And please bear in mind, I'm talking here about litigation procedures that have been initiated already, but I'm not talking about the other ones that could be initiated and that would be in need for the need for additional resources should be carried. And that's why there are two very big participants that we can highlight, funds specifically created to invest in third-party funding procedures or in situations where they're going to be the third-party funders. So there is Lex Finance, created in Peru, that is looking all over Latin America and also in Brazil, investing quite a lot. And Leste Investimentos, this was created in 2014, and it's quite well known for their work within the third-party funding in Brazil. There are a couple of chambers in Brazil that are already dealing with the situation. And in terms of the specific legislation in Brazil, there is no specific regulation about the subject. However, of course, the chambers in Brazil, they tend, number one, to follow international guidelines and principles about the subject. So that's a very good element. In addition to that, some of the chambers and associations, they have themselves certain regulations. So we can see some chambers regulating the matters, but really in line with the trends that we see internationally. And in terms of the Brazilian law regulations, I mean, this sort of institute would be seen as something analog to an investment. So some undertaking of distressed assets or creditor funds, in which one of the parties would be betting against the risk of that proceeding, and of course having an upside in the near future. So all things being considered, it is not a legal procedure or a procedure that per se is challengeable. Of course, that we need to be mindful about the principles of arbitration and regular process of law in Brazil in terms of conflict of interest and others, but it's acceptable. However, as I said, this is a fairly new practice in Brazil, and the ones who are going to have recourse of third-party funding should be mindful that on the one hand, there is little understanding in terms of the courts, tribunals, because a few challenges have been made to such situations in Brazil, but there is a fairly common understanding of its acceptance and also its feasibility. So it's all about understanding if you have a case, if this case is winnable or defendable, depending on which shoes you are, your ability to allocate resources on that, and how interested would it be for you to have someone else supporting you during this claim, and you sharing the proceeds of this claim with this third party should you be successful. Of course, if you want to be an investor that is investing in third party funding, this is also a market that you should look carefully, because you're going to find some very interesting opportunities over there. So happy to further discuss later in the comments and Q&A session. But third party funding can be, in a nutshell, something that can enable people to pursue feasible claims that they wouldn't have the resources to pursue otherwise. Thanks.
Thank you, Delbert. It's very, very interesting. And in my practice, we currently negotiating for 2 clients of our law firm. We are in touch with third-party funding funds. And what can I say from my experience with them is, of course, before financing a claim for a party, these kind of are performing a high level of due diligence about your chance of success of your claims. And sometimes even your claim have positive possibility of success, they can assess that the risk is too higher because at the end of the day, they are just paid by success fees. So they can just reject to finance your claim. It's a possibility that every party should be mindful. And that's why, particularly in such a current period where we've seen a lot of, I would say, dispute relating application, execution of contracts, we should and particularly have in mind that the ways that you will draft your contracts, commercial contracts, during this period of coronavirus is crucial. And we will hear from Maeva Slotin, our partner in Hong Kong, who will give us, I'm sure, that key elements to secure your contracts during this specific period of health crisis. Thank you.
Thank you, Ali. Well, the new background is that we are constantly reminded that we are not back to business as usual. Two examples in Hong Kong of what I would call the new normal is that since January 2020, workforce experiences an indefinite period of stop and go in the matter of going to the office or working from home. And whenever the government of Hong Kong announces that civil servants shall work from home, so do businesses in Hong Kong, which have the option to do so. And the last period of generalized work from home started on 20 July 2020 and finished on 23rd August, so 1 month. And another new normal is that since mid-March, anyone arriving from overseas in Hong Kong shall subject to a 14 days compulsory quarantine. The legislation was initially for a couple of months, and it has now been extended until 31st December, which has huge consequences on Hong Kong and how we do business in Hong Kong. And more generally, worldwide, we shall expect the new normal to include public services closures, which will mean we cannot rely on postal services as we used to for delivering parcels or registered letters. School closures, which will add additional pressure to the workforce, especially those with young children, 14 days quarantine, lockdowns, transportations and courier services restrictions, as it happened in China after the Chinese New Year, some bans on resumption of production after public holidays, manufacturers closures, supply problems, etc. So how do you adapt to this when you are negotiating a contract or considering the renewal of a contract? So we have put together 4 propositions, which are: first, check your options before entering a new contract. Then anticipate obstacles, because there will be obstacles. Review termination, force majeure, and hardship clauses. And lastly, include effective dispute resolution mechanism. So check your options. What does it mean? Basically, it means choose your suppliers and choose your clients. For both of them, I think the main question is, do they have the capacity to fulfill their obligations? The worst case scenario one of the worst case scenario we have seen here in Hong Kong is one of our sourcing clients. So it's a middleman company between a manufacturer in China and final client or distribution company in Europe. And this sourcing company is asking for a down payment from its client in Europe, and with this, it has to pay the manufacturer in China. And what happens when you have done the down payment and even the full payment, and the manufacturer closed because because the employees have not been paid for months, they have seized the goods, and you will never be delivered. So, well, basically, this sourcing company is really in a hard spot, because what happened in China doesn't exonerate, in the absence of any contractual provision, there is no exoneration of the liability to your client in Europe. So check the, basically the cash flow, the resilience of the parties with whom you are contracting, and you have very valid reason to do so at this moment. You should consider asking difficult questions. For instance, whether the supplier you are considering is indeed up to date with payments of salaries and of other overheads, and this is really important, because you don't want to enter into a contract which has a high percentage of chances not to be complied with. Checking your option may also include considering other suppliers, maybe closer from home, closer from the place of delivery of the goods. It could be Europe, could be Eastern Europe, could be North Africa. There are different options for sourcing, and the cost of logistics, which has increased currently, is also another factor to take in consideration. The second point is anticipate obstacles. We don't know which one they will be, but we can expect that in the months to come, there will be new temporary local lockdowns, as it happens in July. There was a new lockdown in Melbourne, in Australia, and further lockdowns in northern Spain. So two recommendations with this regard. One is not new, and that's something which may already be part of your standard agreements, is to have key personal clause. So one of the key to the success of an ongoing relationship and overcome COVID-19 related challenges is to have good contract management, which implies the identification of the key roles on both on all parties to the contract, and identify the responsibilities of the parties, and make sure that each party identify a representative who has the authority to act on behalf of the party it is representing in relation to the dealings with the other party, and obviously a mechanism to replace this key personnel. The other suggestion you may not have already in your contract is to have as a general notification and mitigation duty. The idea here is that, any event, whether local or, as mentioned earlier, new lockdowns or default of a subcontractor, or local, like a new public health emergency of international concern by the health organization, should be notified by the party which anticipates it may have consequences. Because the first thing to manage the new challenges is communication, and the second is a duty to mitigate the resulting breach of contract, if any, and harm to other parties. Our third proposition is to review the termination, force majeure, and hardship clause. So review termination provisions is asking with a fresh eye in which option you might want to terminate the contract. And I would suggest that this is a place where you may address a question which is very often raised in the context of the COVID-19, which is to allow one or all parties to terminate the contract if it's no longer profitable. In case of change of circumstances of the contract, this may be, the termination clause may be just the right place to have those provisions, subject to adequate safeguards, obviously. Another point to consider is to insert or review a force majeure clause. And with this, with regards to force majeure clause, from my point of view of practicing lawyer in a common law jurisdiction, there is clearly a dividing line between common law and civil jurisdictions. Civil law jurisdiction, sorry, because in civil law jurisdiction, just like Brazil, France, or China, force majeure is defined by law, which means that the authorities are very well aware of the fact that, well, these provisions are likely to apply, and there may be some uncertainty, and they may come basically to the help of the parties. And that's what happened in China with some local authorities providing for certificates of force majeure, which has helped Chinese parties to claim the application of the force majeure clause.
Maeva,
yes.
Before to move to the next topic, could you put a last word regarding the...
I just very quickly. So basically, the point here is that civil law jurisdiction, there is a basis in the law, which you have not in common law jurisdiction. Everything will hang within the drafting of the clause. So it's really important to consider where is the other party you are negotiating with, and if this other party is in a civil law jurisdiction, you need to check what are the local provisions of the law. It is very similar regarding hardship clause. You find the same dividing line between common law jurisdiction and civil law jurisdiction. Now the last point, and it will close the circle, as Ali is suggesting, is that you need to make sure that the options chosen regarding the governing law and jurisdiction clauses are effective. You don't want the stalling of a dispute caused by court closures or unavailability of remote communications with the court and or video conference hearings. So with this, just one last point to say that Hong Kong has important age as a choice of place for administered arbitration for litigation related to China. Since October 2019, there is an arrangement between mainland China and Hong Kong for interim measures in support of arbitration in Hong Kong. So with this, I think it's these are the most important points I wanted to cover.
Thank you, Maeva. It was really interesting. Nevertheless, the party, even though they will introduce all the clauses mentioned by Maeva and take all the reasonable precautions that they will anticipate, it sometimes, unfortunately, leads to a dispute, and we have to deal with that. And we have seen with our previous speaker how arbitration, institutional arbitration, and ad hoc arbitration could be a solution, efficient solution. But as we said, this solution is litigation solution. So it takes time, it takes cost, energy, it's time consuming, and sometimes we have to contemplate it some alternative way to resolve the disputes. That's why it seems to us really important to have now a focus on the other alternative solution, such as conciliations and mediations. And Fabien Gagnero, working in UGC law firm in Paris and as well animating our India desk in Paris, will talk about conciliation and mediations. And we will then have a focus of our resident partner, Jean-Nicolas Goussen in Belgium, who will also highlight specifically this type of alternative in Europe and especially in Belgium.
Thanks, Ali. Yeah, just before we move on to the actual topic of conciliation and mediation, just wanted to make a quick snapshot of the situation regarding India's court system. If you look at the picture now, there are more than 30 million cases pending before Indian courts. 30 million. Roughly every year we have an additional 4.6 million cases being filed, all topics considered, before civil courts. So as you can see, the subject of problem of delay and enforcement of contract before Indian jurisdiction is a major issue, and it's been so since, I wouldn't dare to say since ever, but since a fairly long time. So basically, because of that, we have had a significant and historical practice of arbitration, especially ad hoc arbitration, happening in India, and that's something that a lot of companies are fairly familiar with. Now, if we look at the situation of international dispute resolution, of course, we tend to see a fair share of arbitration before institutions such as the SIAC in Singapore, such as ICC, etc. Now, as we said before, arbitration with such institution has a lot of merits. It has a lot of advantages, but the main difficulty, the main problem is the cost. So just so that we have in mind that the average money claim before ICC is something like 100 million. That's the average claim being filed before the ICC. That doesn't mean that you don't have any more minor cases, but it still means that's something that is quite high, that's not reserved but privileged by higher business claims. Now, if you come back to conciliation and mediation, that's something that is fairly envisioned, talking about Indian laws in general, but I would say that's something that's quite small in terms of practice for a number of reasons. But if we start by trying to differentiate the two notions, what is the conciliation versus mediation? Well, from an Indian law perspective, one would say that conciliation is much more organized way of the alternative dispute resolution that is being envisioned by the law and by the specific act, Arbitration and Conciliation Act, where basically the parties can always opt at all times for conciliation, where under the patronage of the judge, if one may say so, and if they both agree on initiating that conciliation process, there'll be a certain number of texts of legislation backing it up. So at the end of the day, if you reach an agreement, the law would say itself, fair enough, that conciliation, that agreement that results from the conciliation process would be like an arbitration award. So that is something to align both systems together and saying, okay, we may have like full-fledged arbitration, we may have a conciliation, and if a conciliation gives something up, that would be the same as arbitration. Good. Now, if we move to mediation, that would be something that is way more flexible, way more informal. You may have provided so in your contract, in your agreement, or not, or you can just simply decide to go for that. And there's only one sentence in the Arbitration and Conciliation Act saying that parties are free to go for that. Now, the biggest problem we may have had regarding mediation is it's not the same outcome, legally speaking, as in conciliation. If you have an agreement, it's the same thing as an arbitration award. Good. If you reach an agreement under a mediation process, that's any kind of contract. So basically, you may have like a kind of settlement or transaction agreement, whatever you name it. But the main problem would be for you, what if that contract is not enforced? Then you're back to square one. You have to again initiate whatever dispute resolution you provided under that agreement. So you had that question of what is, I need to give some kind of legal weight, legal background to that mediation agreement, and we'll see just, that will be my last remark. We have now encouraging signals to regarding that topic specifically. Now, I started by saying that in India, we have a strong culture of arbitration that is growing. I think it's not a small thing to say that the 25,000 case that was registered by ICC was a case involving an Indian party. So that's quite a symbol. They are exploding in terms of represented parties in arbitration matters. Now, for conciliation and mediation, it's quite, I would say it's quite small in practice, in my practice as I recognize it. I think fair to say that in everybody's practice, it's quite small. Why is that? I would say that there is a lack of, probably a lack of information, like clients are not so informed into that kind of practice. There was the question of enforceability, which I addressed. It was also perceived as a source of delay, because if we have to get back to a court to have my mediation agreement enforced, then it will be some more time. So that's something that is quite small. If we try to look at a few statistics, it's been quite difficult to find precise numbers. But for instance, in 2017, ICC recorded, I think it was like up to 30 new filings for mediation for the full year. So it's quite small. There is a Singapore International Mediation Center that is also very active and very present in Southeast Asia, with which is the mediation equivalent of SIAC for arbitration. I don't think that the amount of cases are far above like the dozens, let's say, per year. But I'm be happy to stand corrected if anyone has other figures. So that being said, that means that it's quite small. I think in the light of COVID, it will obviously be something to be considered, because you have maybe no other options for, especially for medium and small companies. You want to go to ICC, you want to go to SIAC for arbitration, fair enough. It's awesome, it's quick, it's tailor-made, etc. But it costs money. So if you are a medium-sized company, you need to find something that is more flexible, more enforceable quickly. So in that light, mediation would surely represent a way of going forward. We have to say also that I would say not most, but I would say all mediators or mediation institutions offer online hearings, online proceedings to move ahead more quickly. In Paris, we have a CMAP who also provides such facilities. So now we stand in a kind of a trend, perfect environment to develop mediation and conciliation, with a lot of offers, professional offers, institutes providing such facilities. We also have the Convention of Singapore that has recently been implemented, where we say that we basically fill the loophole that I was mentioning before. That is to say that we give the same weight, legally speaking, to any agreement that is the result of a mediation process as an arbitration award. So that means to say that now arbitration and mediation are both recognized as an equivalent way of alternative dispute resolution, and that is probably for the best in the current environment.
Thank you, Fabien, for these very interesting highlights regarding the use of conciliation and mediation in India. We will now hear from Jean-Nicolas Goussens, our UGGC partner in Belgium, who will talk about this topic of conciliation and mediation and the particular view of the Belgian law. Jean-Nicolas.
Yes. Thank you, Elie. Well, I tried to make a little link to what was said before, but focused from the Belgium side. As explained, and into account the appearance of the unknown contractual issues from arising from the COVID-19 crisis, we will most probably see the number of conflicts and court cases increase. Now, like we heard before, in some countries, and this is also the situation of Belgium, since years we know what we could say judicial backlog, and this means that the delays for traditional resolution of disputes before court takes merely a lot of time. This delays is one of the reasons of developing what we said alternative dispute resolution of ADR. The COVID experience constitutes certainly a good reason to promote by drafting the agreements the introduction of the IDR clauses. This is the idea that we try to avoid the court cases prior to the emergency of any disputes. But before inserting, and what we already heard, ADR clause, and certainly in cross-border situations and contracts, the national and international rules must be checked before, and this concerns, for example, the admissibility, the consequences of a suspension of the proceeding, the confidentiality of the ADR, the enforceability of the decision. In accordance to the contractual freedom, when disputes exist, the parties can agree of an ADR, a valid ADR clause or ADR agreement must comply certain conditions. These conditions is the valid consent of the parties. We have also to determine which type of disputes does the clause or the agreement apply to, and which ADR mechanism will be applied. The scope of the alternative dispute resolution mechanism is very large and is certainly in permanent evolution. We can refer to collaborative practice or hybrid procedures, which combining different alternatives or amiable methods. Now, for ADR, we heard it before, arbitration is certainly one of the most traditional form or ADR. And in connection with what's said before, what we can say is that in Belgium, the arbitration rules and organization are provided by our judicial code. And the last update concerning the arbitration was the alignment of our local rules with the in situ rules. We spoke before concerning institutional arbitration, but also in Belgium, we know the ad hoc arbitration. Concerning one of the major points, and it's the enforceability of international decisions. Well, Belgium signed the Convention of New York of 1958, but is also signed also the Convention of Genève, and some bilateral old treaties exist. For example, we in Belgium, we know a treaty with France from 1899. Now, internationally, mediation is also, I think it was spoken before, is also mediation is reconnected on international base. Now, totally recently, we have the Convention of Singapore. Now, Belgium as member of the UE has not signed yet this convention because the European Union is currently examining whether it could sign this treaty on behalf of its members or whether each member state would need to sign this treaty individually. But this do not mean that we, on international side, Belgium has no international instruments, and one of the important instruments concerning mediation is certainly the directive of 2008 regulating the certain aspects of mediation in civil and common commercial matters. The European directive provides the objective to facilitate the alternative dispute resolution and to promote the use of mediation. The directive is also applicable on cross-border situation. It's for the member state and the courts to determine the enforceability and validity of the mediation clauses. What's important between the difference between mediation and arbitration, it's that the directive underscores that the national legislation that would make mediation compulsory should not prevent the parties from exercising their right to access to the Belgian judicial system. This is in opposition with the arbitration. In arbitration, we can have a final arbitration decision. Now, the mediation was introduced in the Belgian law in 2005 and quite recently in 2018 we had a new law, and this new law has come into force on January 1st, 2019. This update confirms what we spoke about, the conciliation mission of the judge. And this new law gives also a mission to the judge to promote mediation. A fundamental amendment is that the judge now in Belgium may now decide to impose a mediation process, since the parties may only oppose it jointly. It's sufficient before a court case that one of the parties is in favor of the mediation to obtain a court order to impose this mediation process. With the law of 2000, of 2018, we note here in Belgium 3 kinds of mediation process. It's the totally or entirely voluntary mediation, and this mediation process is totally outside of the framework of the judicial code. This means it's a kind of ad hoc mediation. We have then also the judicial mediation. This is ordered by the court. And then we have a non-judicial mediation. It's not ordered by the court, but it's covered by the framework of our code. And finally, something special in Belgium is that this law of 2018 introduced a major novelty, and this is the introduction of the collaborative law. How to describe the practice of collaborative law? It's a practice who could be described as a voluntary confidential negotiation process involving the parties and their legal advisors, most of the time attorneys. The lawyers have to undergo a training and needs an official accreditation. And in the difference with mediation is that in collaborative practice, we have no independent third party involved. Like we know by mediation, the mediator has to be independent, impartial, and has to be certified. If the collaborative process, where we have only the 2 parties or the parties and their lawyers, if this process fails, well, the Belgian law provides that the lawyers may not defend the interest of their clients before court. The law of 2018 introduces also a new responsibility. For example, for us, the lawyers, we are legally requested to inform and to promote, if possible, the alternative dispute resolutions. According to the Belgian court, we can say that nearly all disputes, even cross-border disputes, can be subject to mediation or to collaborative practice. Even public entities may also submit their disputes to mediation. Now, there exists some exceptions to mediations, and this concerns principally cases before the Supreme Court in Belgium. With the update of 2018 introducing collaborative practice and to update the mediation, we can say that in Belgium obtained a legal framework concerning accreditation, regulatory bodies determining the rules, code of conduct and protocols, and some other principles were let down. This means that the ADR, the law says that there is a confidentiality of the negotiation, and precise also that the court case, as the protocol is signed, we have a suspension of the prescription. Another point who's covered by the law is the enforceability of the settlement agreements, and also we find principles of cost dealing. This means that the law of 2018 modified the philosophy of the resolution of disputes, and it changed fundamentally the position from a court resolution to an ADR resolution. The legal framework was existing before the COVID crisis, but we expect that with the consequences of the COVID crisis, the ADR will be omnipresent in the case resolutions in Belgium. Thank you.
Thank you, Jean-Nicolas. It's really interesting. It demonstrates the trends in Europe tending to have more and more a legal recognition of the ADR. Now it's time for us to open the floor to every attendant who potentially have questions. We are between us and ready to address your questions. If you have, don't hesitate to send us a chat on the web app, and we will be happy to talk about it. One question before maybe to receive from the participants, one question that we have and we face and we can discuss a few minutes about it. As we said, institutional arbitrations, chambers have promoted and encouraged to continue all the pending arbitration during the health coronavirus crisis, meaning that there is a clear incentive from the arbitral chambers to continue the litigation pending, arbitration pending, and to move forward. Meaning when there is travel restrictions, continue to set up hearings and virtual hearings. So a common questions that we have is how to secure these virtual hearings, one, and two, what is, I would say, the advantage and inconvenience about the virtual hearings, and in particular, does such type of hearings, virtual, have an impact on the directions and the sense of the award by the judge? It will complicate the judge the arbitrator to deliver the award. It will facilitate them. I will start to share my own experience regarding that. Regarding the first issue, technical difficulty to have virtual hearings. It's basically the main difficulty is when you have different party in different time zone. First of all, you have to be very aware that it's not like you have physical hearings. Everyone is in the same rooms at the same time here present. When you have virtual hearings, and especially in international arbitrations, you have to consider the time slots and the time differences. Secondly, you have to take into considerations the system, the internet system in each local party. To have made some international arbitration in Africa, and the last one was in Mauritania. It was an ICC arbitrations, and I could say that the level we have several conferences for settle the process, the calendar, the hearings, and it was difficult for one of the parties to have a system who allow us to hold some virtual hearings in the satisfactory condition, because sometimes it's not at the level of the legal advisor or the parties themselves, but sometimes the flow the debit of the internet in some country, in African country, is very low. And it's very difficult to have something very which is agile and dynamic, which is necessary to hold virtual hearings. So sometimes technical issue can appear and could be problematic, and we have to deal with. Secondly, regarding I would say advantage and inconvenience of virtual hearings. Advantages is really good because first of all, in the time where we have some restrictive and sanitary rules that apply in most of the country. For instance, in France, you cannot have 10 people in the same room in a hearing. So so basically, virtual hearings will help us to deal with these sanitary restrictions. Secondly, all parties have to be mindful that the virtual hearings will never replace totally a physical hearing, because when you're dealing with cross-examination of witnesses, of experts, nothing will replace, I would say, the truth of the moments, the possibility for the administrator to feel the sincerity of the party during the physical hearing. So this is one of my experience with virtual conferences of arbitration rules and virtual hearings.
If I may just add up and complete, of course, I completely agree with that point. On that very last issue you mentioned, one cannot stress enough the importance of indeed the true, the reality of human interaction in real life. I'm sure that all practitioners around the table and around our panelists online have met with such instances where you have, whether a court hearing, arbitration hearing, mediation hearing, whatever the support, the legal support of that meeting, where after exchange of argument, we have a break, like people will have separate short meeting on their side, and then the counsel can speak together and they come back with an actual solution to the issue. And you may be in court hearing, you may be in arbitration, and suddenly there is something that emerged from presumably late night or long hours of hearing together. So yes, indeed, that is quite the symbol of our time, the symbol of the crisis, to have virtual proceedings. That's very helpful. We've done recently some court hearing online ourselves. So it is very necessary right now, but I hope that it won't be a complete substitute for whatever we have in real life litigation and arbitration.
Thank you, Fabien. We receive a question from Luc. Based on our experiences, what are the key points for an effective mediation? So I will ask maybe Jean-Nicolas and maybe Fabien as well, if you want to add something. Jean-Nicolas, what, in your experience, are the key points?
Well, as explained, mediation is covered by the Belgian law, and this means that if you want to have a mediator, you need here in Belgium normally mediation with accreditation. This means that the mediator is formed and has to be updated in his formation to be recognized as mediator before court. Now, this does not exclude the ad hoc mediators, but the problem is with the ad hoc mediator. It's most of time we have to answer to the question if it's not an accredited mediator, has we the possibility to obtain the enforceability of the agreement or settlement.
Yes, thank you, Jean-Nicolas. Before to give the floor, maybe Fabien will add something regarding the key point for an effective mediation. From my experience, one, and especially for ad hoc mediations. And sometimes, even if you have recourse to mediation institutions, the key point is the quality of the mediator. First of all, the person that you will appoint to do the mediation. So one, you need to have like mandatory skills and quality. The first quality is independency, to be sure that his independency will be not questioned or suspicion by one of the party. If it is, you can be sure that the mediation will fail and there is no positive outcome possible for such mediations. Being said that, we can add another thing, the skills of the mediator. You have to choose a mediator who knows the business, who knows the subjects. It cannot be someone who just knowing the law, because you're not just dealing with the law in mediations, you're trying to reach a point of consensus between the parties. So knowing the business, the competencies of and skills of the mediator, from my point of view, will be a key point. And of course, and it will be my only point, a mediation is for me a credible alternative option when you have a dispute who can be mediated and solved, because sometimes it's too late. The dialogue is broken between the party, and even though you bring the more experienced and skills mediator, it's too late, because you can have a bad faith party who trying to take advantages for the COVID crisis. We have seen that for our clients. You can have some inconsolable difficulties, and sometimes mediations will be just losing times for the party, time consuming for nothing. It's indeed something that it's completely subjective and have to be appreciated on a case by case basis, but you have to assess if mediation could be as a positive outcome, and just a case by case basis appreciation at the end of the day. Fabien?
Absolutely, I concur with everything you just said, and to add up on that, yes, indeed, the question of the mediator is a key point here. Like, you have to, as Ali said, have someone independent who knows the business well, etc. To reinforce that last issue you addressed, it's the question of knowing where to stop. So I was about to say that, you know, the mediation process is very important to be well organized with a paced rhythm, so that we have like something that moves forward. And the strength of the mediator would be to know how to stop and to know where to say, okay, that mediation process is a done deal. We cannot go any further. The last point maybe I wanted to address was the question of do you go to a mediation process with your counsel or without your counsel? There again, there could be a point in saying normally you come with your counsel at a mediation, but there could be a point where the mediator could want to speak to, you know, people to people outside the presence of their respective counsel, to try to have a more direct approach. So it's all the talents in, I would say, the management process of the mediator that could be at stake here.
And Maeva, I think you want to add something to address your questions.
Yes, indeed. It may be a cultural differences, but from my experience in Hong Kong, mediation is effective when the parties have already clearly set out their positions, both at law and at facts, which means that as part of a litigation, it's most effective after the closure of the pleadings part. So arguments have already been exchanged. Parties have already incurred significant costs, and before they incur more, because litigation in Hong Kong is expensive, then this is the right timing in Hong Kong to say, hey guys, why don't we try to sort out this differently? And because the way it works, well, in Hong Kong is that if you suggest mediation too early in the litigation process, a party may just reject the option because, well, they feel they have a very strong case and they don't realize that the other side feels the same, basically. So that's, but it may be a cultural difference.
Thank you. It's really interesting. Any other question? Okay, so I would like to thank everyone once again, our partner, to the French Chambers of Commerce in Brazil and the brilliant Chambers of Commerce in Paris to help, and all the speaker and the partner of UGGC network to their contributions. Thank you to the attendant for participating to such webinar. If you have, don't hesitate, you have our email address on our website. If you have any questions, any partners here will be really happy to address that and to answer you by email. Thank you again, everyone, and have a good day. Bye-bye.
Thanks a lot. Bye-bye.
Bye. Thank you.